So we're now working through the alphabet to Bork. This is, we've got a great panel here of, I think there'll be some interesting contributions, discussions of Robert Bork and his influence here. As one of the early arrivals with Henry Mann when he got here and Henry was building our faculty, Robert Bork played an important role because I don't think we hired any con law scholars in the first 4 or 5 years we were here. We were the only law school in the country where people were not fighting to teach con law. So it was a distinctive place. And so Robert Bork came on board and helped us out in those days and had a lot of influence on law and economics and the development of the school. So we'll start off with our new full-time faculty member, Doug Ginsburg.
Took a few years to find anybody who would teach con law the way we would want it taught here, and it's worth waiting. I think maybe Victor Vanberg could have done it. All right, I'm going to talk about Bob's influence on the courts with respect to antitrust law. The open textured nature of the Sherman Act, passed in 1890. Inevitably, maybe not inevitably, but certainly gave the judiciary a great deal of responsibility for interpretation. The Supreme Court itself has referred to the Sherman Act as being sort of quasi-constitutional in that it's so brief and states such a broad principle. In 1966, the state of the Supreme Court's antitrust jurisprudence was abysmal. It was incoherent and an embarrassment. And Bob set out to do something about that, not as a friend of the Supreme Court, but in order to discern what he could of the meaning of the Sherman Act. And he undertook, quite aware of the frailties and drawbacks of relying on legislative history, he undertook a very extensive review of that legislative history to dig up what principles he could find that could lead the judiciary to decide cases in a rational way. And to give you a sense of just how bad things were, Learned Hand, revered as one of the great appellate judges of the 20th century, had read the Sherman Act as intended to, and I'm going to quote his words here, to minimize the helplessness of the individual, to ensure the organization of industry in small units, and so on. These ideas were highly malleable. The whole interpretive enterprise was one of judges looking into their own reflection and deciding what the act should mean, rather than having any foundation for saying what it does mean. And it could justify just about any result in this manner, which is why the state of the law was so incoherent. The ultimate statement, again, goes to Judge Hand, saying the Congress delegated to the courts the duty of fixing the standard in each case. So there was no transferable standard, nothing that transcended one case really and guided the next. Bob's examination of the legislative history was not, I don't think, undertaken dispassionately. I think he had a hypothesis, and he was, as with anyone plumbing through the sewer of legislative history, was finding what support he could for his view of a rational interpretation of the Act. So he concludes his article in 1966 by saying the legislative history contains no colorable support for application by courts of any value, premise, or policy other than the maximization of consumer welfare. Now, this was a statement and a judgment that proved to be not only controversial as to its authenticity as legislative history, but also as to its use of the term consumer welfare. Now, Bob was quite specific in saying what he meant. He said by consumer welfare, he meant the maximization of wealth or consumer want satisfaction. So the distinction that's drawn now and has been for a long time between consumer surplus and producer surplus is elided in this formulation. And it probably best approximates, what he was saying best approximates total surplus. He understood and was quite frank about the fact that the framers of the Sherman Act didn't speak in these terms at all, that he was encapsulating a lot of statements of less clear than that. But he thought they did, well, they didn't speak with the precision, as he could put it, of a modern economist. They had some of them had some definite ideas. The common denominator of the act being tied to this notion of consumer welfare as he defined it, that common denominator being the condemnation of cartel agreements, of monopolistic mergers, and of predatory business tactics, as opposed to monopoly, which is not prohibited by the Act. As a monopolization, but not monopoly, is the prohibition. Monopoly can arise from superior efficiency, and that was an important distinction that needed to be kept clearly in mind in the interpretation of the Act. The visceral reaction to monopolies, I think, led Judge Hand and others to condemn things that really reflected no more than superior efficiency of large firms, some large firms. In 1966, this thesis was entirely novel, utterly. By 1977, it had become the conventional wisdom in the federal courts. That was the year when the Supreme Court decided Continental TV against GTE Sylvania, which caused it to repudiate and overrule a case that had decided just 10 years earlier, the Schwinn bicycle case. In the earlier case, the court had held that it was a per se violation of the Sherman Act for, quote, for a manufacturer to sell products to his distributor subject to territorial restrictions on resale. So regardless of, in other words, the actual and possibly efficient economic effects of a territorial restraint in a vertical relationship, is held per se unlawful. That was a case where it was a retailer selling television sets and was unable to relocate to another location under the terms of the distribution contract. When the court overruled Schwinn in Sylvania, they said, quote, per se rules of illegality are appropriate only when they relate to conduct that's manifestly anti-competitive, and that vertical restrictions promote intra-brand competition by allowing the manufacturer to achieve certain efficiencies in the distribution of its products. Focusing this way on economic efficiency to the exclusion of other values. Nothing in here about small retailers or the evils of vertical control. The court implicitly, in this instance, adopts Bob's thesis. And in the concurring opinion, Justice White actually attributes the court's view to of the Sherman Act as directed solely to economic efficiency. That's White, and cited Bork's article as the source of that position. So the inroad was made in a case that really began the complete revolution of the rethinking of antitrust law, the overruling of one decision after another by a unified Supreme Court, repudiating decisions that had been made without the benefit of any economic insight at all. Tim Uris, I think, captured the importance of the matter. He said, the opinion was a ringing endorsement of the economic approach to antitrust law. It was only a couple of years later, in the case called Ryder against Sonotone, that the court explicitly quoted and relied upon Bob's 1978 book, The Antitrust Paradox. The 1966 article had become a chapter in the 1978 book. And the court flat out declares that the legislative history, quote, suggests that Congress designed the Sherman Act as a consumer welfare prescription, see Bork, The Antitrust Paradox. By the mid-'80s, this thesis, Bob's thesis, had undeniably changed the court's fundamental understanding. It was not just a citation supporting a view based somewhere else. Now, in the intervening years, the court has adhered to this view. It hasn't gone back and re-examined the legislative history, but it does make occasional references to the purpose of the act, most recently in the Legion leather goods case, in which it overrules a 99-year-old precedent that had made resale price maintenance per se unlawful. And every court of appeals has followed the Supreme Court in explicitly stating that the purpose of the act is either to serve consumer welfare or, as the Supreme Court itself has restated the matter, the preservation of competition, not of competitors. The challenge to Bob's thesis, oddly, did not really begin until after the Supreme Court had cited it. It's floating out there from 1966 on, and there is no academic rebuttal. But of course, once it's cited favorably by the Supreme Court, the blood it can be smelled, and the critics start to circle. There have been about a score of articles critical of the consumer welfare thesis as a matter of legislative history. And two distinct and different strands of that criticism have emerged. One is held by Herb Hovenkamp, who is the inheritor of the Eureka Treatise and the leading commentator today on all matters involving antitrust. He contends, having reviewed the legislative history, that the primary purpose of the Sherman Act was the protection of small business, not of consumers. The legislative history itself and the attendant political circumstances in which it was passed, he thinks, show that the Congress acted neither solely on the basis of efficiency nor solely to benefit consumers, but primarily to avert various kinds of injury to competitors, flowing mainly from the lower costs of large and more efficient rivals. The other strand of criticism emerges from Bob Land of Baltimore and his co-author, Kirkwood, who agree that the Congress was concerned about some producers, not just consumers, but nonetheless reject the broad socio-political, big business is bad, small business is good rationale for antitrust. This was the rationale that underlay the anti-chain store acts and other devices that were aimed directly at the states and large businesses. But Land and Kirkwood argue that the legislative history supports only, quoting them, a congressional desire to help protect sellers from being forced to sell at prices below their competitive level, close quote. Now that's probably a reflection of the references in the legislative history to the Standard Oil. The challenges brought by Land and Hovenkamp are representative of the Academy as a whole. Almost every one of the 20 critical articles falls into one or the other of these two camps. One of the commentators goes so far as to say that Bork's interpretation has been almost universally rejected by antitrust scholars. And I think that's, I guess it's almost, perhaps allowing for the possibility that there might be me. And the Academy has failed utterly to persuade the judiciary, even to question or re-examine the premise that the Supreme Court adopted by reference to Bob's work. The consumer welfare thesis has become one of his many enduring contributions to U.S. antitrust law. regardless of whether his view of the legislative history is correct, the Supreme Court's endorsement of consumer welfare as the exclusive value underlying the antitrust laws has had important consequences. Now, I should say, as a qualifier, the court has not been confronted with the question of whether it should be focusing on total welfare or consumer welfare. Bob's use of the phrase is somewhat ambiguous and readily comprehends total welfare. That's an issue that's been confronted primarily by academics, but not by any courts in the U.S. Here are the three consequences I think we can discern and attribute to Bork's work. It has substantially ameliorated the uncertainty that prevailed when the courts were freely choosing among multiple, incommensurable, often conflicting values. Leah Brannon and I did a paper 5 or 6 years ago showing that most Supreme Court cases now in antitrust, indeed there's only one exception in the last 20-some years, are decided by supermajorities of 7, 8, or a unanimous Supreme Court. So the reduction, is that my timer?
Well, it's my time.
1 minute. Then you'll owe me one. So the reduction of uncertainty really has facilitated business planning. I think everyone, councils, companies knows that. And indeed, one of Bob's harshest academic critics, Chris Grandy, writes that the legislative history of the Sherman Act fails to support the consumer welfare thesis. But the thesis provides a clear and cogent set of rules the courts can apply in antitrust cases, and no other view of antitrust accomplishes that task as well. That's from his harshest critic. Secondly, relatedly, I think judicial adherence to the standard, the consumer welfare standard, has significantly narrowed the range of conduct that comes within the condemnation of the act. Hence, the reversal of so many precedents, always in the direction of narrowing the scope of liability. Vertical restraints, as I showed in an article some years ago, are in effect per se lawful. The first 44 cases to be decided after GTE Sylvania came out 42-2 under the rule of reason. One of the two, I think, was wrongly decided. People do not invest now in litigation over any vertical restraints. Now, with resale price maintenance on the table, that will have to be sorted out with some litigation. Finally, just judicial adherence to Bob's thesis has just about put an end to the efforts of lawyers and the propensity of lower courts, whether received or perceived or real, to manipulate outcomes by using highly plastic, subjective values of the kind that Judge Hand was putting forth. So we can score 1 for the rule of law on Bob's score sheet. I think it's been an unmitigated benefit to everyone. What Bob predicted, what he sought, was to improve, quote, the wealth of the nation, close quote. I think he's done it.
Thank you very much, Doug. Jonathan Adler, Case Westman, is our next speaker.
Thank you, Henry. It's certainly a pleasure to be here. I'm back at my alma mater. I never had the pleasure of having Judge Bork as my constitutional law professor. What that means, if I make any constitutional law-related mistakes, blame Max. Don't blame Judge Bork. And I was asked to talk about Judge Bork's work and thought as it relates to commercial speech. And this presents a bit of an interesting challenge because of those of you who know much about his academic work, Judge Bork wrote a lot about speech, and he wrote a lot about whether or not the Constitution protects economic liberty, having at one point been his career quite in favor of robust protection of economic liberty on constitutional grounds, but later coming to reject that view. But he actually wrote relatively little on commercial speech. But I'm going to try and make some sense of what we can say about what he thought about commercial speech and about how his views on commercial speech evolved over time. I should also say that the relative lack of Judge Bork's writing on commercial speech does not explain my lack of a paper. That's purely my own dereliction, not in any way reflecting the subject matter. Now, as an initial matter, as many people know, Judge Bork, or before he was a judge, wrote quite famously in a 1971 article that constitutional protection should be accorded only to speech that is explicitly political. He believed that this was the proper outcome if one tried to apply neutral principles, or drive neutral principles that could be applied in a neutral fashion to questions of constitutional law. And if it came to any other sort of speech, including speech that had potential political implications, but that was not explicitly political, the First Amendment should provide no barrier to such regulation. As characterized by one scholar, for example, Bork's view was that if protecting speech is linked to the pursuit of pleasure, which certainly some scholars have maintained, that the state should be permitted to regulate speech in the same manner as it regulates other pleasure-seeking activity. Similarly, in the context of economics, if, as Bork had concluded by this time, the state was not particularly limited in its ability to regulate economic activity, it would not be limited in its ability to regulate commercial speech. And despite his continued advocacy of laissez-faire approaches to economic matters on policy grounds, particularly in the context of antitrust, he would stress throughout the bulk of his academic career and later that this was advice to legislatures. It was not binding on courts, and he quite categorically rejected the claims made by libertarian scholars that the Due Process Clause or other portions of the Constitution should be read so as to limit the state's ability to, for example, limit the bounds of permissible contracts or to otherwise limit economic liberty. He was quite critical of Lochner. He gave a speech at the University of San Diego where he gently but clearly disagreed with the positions advocated by Bernie Segan, for example, that economic liberty should be more broadly protected. Now, when it came to speech in particular, Judge Bork did eventually back away from the narrowness of his theory, at least as articulated in the 1971 article, and did eventually come to advocate more robust protection of commercial speech. In 1984, for instance, in a letter to the ABA Journal, he noted that, quote, as a note to respond, because again, as a result of the responses of scholars to my article, I have long since concluded that many other forms of discourse, such as moral and scientific debate, are central to democratic government and deserve protection. It is interesting to note, however, that he noted things like moral and scientific debate, but did not mention commercial speech. He would, though, continue to stress that there was no rationale in his view for protecting either obscenity or any form of pornography. Similarly, in 1995, he would write in Commentator magazine about the First Amendment that the existence of the amendment implies there is something special about speech, something that sets it apart from other human activities that are not accorded constitutional protection. And for Bork, this was, quote, the discovery and spread of political truth. Not moral truth, necessarily, not scientific truth, not economic truth, but moral truth, but political truth. And he commented on his 1971 article that he had mistakenly arrived at the proposition that the only explicitly political speech should be protected by the Speech Clause. He explained that political speech does have a special claim to protection. A representative democracy would be nonsense. Would be nonsense without it, but there is both a practical and a theoretical objection to limiting protection to explicitly political speech. The practical objection is that other forms of speech could find protection if the speaker added the admonition that we pass a law on the subject, whatever it was. The theoretical objection is that speech is both valuable and unique, whatever kind of truth it seeks to discover and spread. There is thus reason to conclude that the protection of the speech clause extends to many other types of speech that express ideas. And throughout his commentary on the First Amendment, on speech generally, which was a frequent subject of his writing, he would note the Supreme Court's, in his words, stunning inversion of the First Amendment's guarantee of freedom of speech, protection of the worst forms of pornography and vulgarity, but approval of even prior restraints on political speech, historically at the heart of the amendment. But as I noted, relatively little discussion of commercial speech as such. And stressed that much of the reason for expanding protection was the practical concern that, for example, requiring courts to comb through material to figure out whether or not something was sufficiently political to constitute political speech would be, in his view, an administrative and legal nightmare, and that much political speech could be chilled because, quote, no speaker or writer could proceed with confidence that the unknown judge and jury he would one day face would draw the political, non-political line correctly or consistently with the determinations of other tribunals. He would write quite late in his career that for that reason, a framework articulated in cases like Czaplinski that identified particular types of speech that could be excluded from First Amendment protection altogether was pretty much the best the courts could do. And that there are some types of speech that are of such slight social value as a step to truth that their regulation or prohibition would not threaten First Amendment values. But again, through most of these writings, relatively little expressed discussion of commercial speech. The one exception is a 1996 backgrounder that Judge Bork wrote for the Washington Legal Foundation, forcefully attacking the FDA's initial proposals to regulate tobacco advertising. These proposed rules would have, among other things, limited the content of tobacco ads to black and white text and would have banned the use of cigarette brand names in event sponsorships and the like. And Bork argued in this backgrounder that these restrictions would be patently unconstitutional. And I think the initial puzzle is what explains this shift. As I already noted, there was a point in time when Bork, as a young scholar, had been quite an avid proponent of the idea that the Constitution protected economic liberties. He somewhat notoriously wrote an article in the early 1960s arguing that the public accommodation provisions of the Civil Rights Act would be unconstitutional infringements upon the right to property. But as a result of his interactions with, among others, Professor Bickle, co-teaching a seminar at Yale, he rejected that libertarian view of the Constitution. One hypothesis was perhaps that his work in antitrust caused him to recognize the value of commercial speech, and the big value of commercial speech perhaps in advancing consumer welfare. As Solicitor General, he did author a amicus brief in the Bates case, Bates versus State Bar of Arizona, one of the Supreme Court's first cases protecting commercial speech. This case, interestingly enough, combined both antitrust and speech questions. The questions before the court were first whether or not Arizona's restrictions on advertising by lawyers were subject to the Sherman Act or could seek shelter under the State Action Doctrine and Parker versus Berman, and then only secondly, if these restrictions were immune from Sherman Act challenge, were they impermissible under the First Amendment? And Judge Bork's brief argued that, in answer, I think with some regret, that the answer to the first question was indeed the ban on lawyer advertising that Arizona had adopted was covered by Parker versus Berman, but that nonetheless that it was unconstitutional. And given that the Supreme Court had just about a year before struck down state restrictions on advertising in the Virginia State Board of Pharmacy and versus Virginia Citizens Consumer Council and Bigelow versus Virginia, it was not much of a stretch to argue that if pharmacies are allowed to advertise and doctors are allowed to advertise, you would think lawyers would be allowed to advertise as well. As the brief wrote, there is a strong public interest in the free flow of accurate information about commercial services and commercial products, and that the flow of information cannot be staunched simply because it has a commercial subject matter. I think it's fair to say that part of the motivation for this brief might well have been the efforts by the Justice Department at the time to constrain state-sanctioned monopolies, and have not found much evidence that there was much effort by the Justice Department to try and expand protection of commercial speech as such. There aren't too many clues in Judge Bork's work as a judge either. He did participate in some important First Amendment cases, although the ones that attracted the most attention, both at the time and when he was later nominated to the Supreme Court, were those involving libel and public protests. His one opinion that he authored that directly focused on commercial speech was a very straightforward application of the Supreme Court's doctrine. Very little clue in that opinion that he was trying to push the law in any particular direction, and I think that does stand in contrast with some of his other opinions. Some of you are probably familiar with an opinion he wrote concerning the application of the fairness doctrine to teletext. The FCC had argued that teletext was different from broadcast, and so that the constitutional rationales for allowing the fairness doctrine to be applied to television broadcast would not apply to teletext. In Judge Bork's opinion on that, he explained how, as a matter of economics, this was ludicrous. He had a nice footnote citing, quoting extensively from Ronald Coase's Journal of Law and Economics article on the Federal Communications Commission, but that went on to say that whether or not the economic rationale was sound or not, he was bound by Supreme Court doctrine, and if the Supreme Court did not have a rational account for why scarcity could justify regulation in some media and not others, it wouldn't be for him to invent one. So what caused this change? Well, I think one reason Judge Bork did eventually adopt a more robust, or begin to advocate a more robust protection of commercial speech is because as he became familiar with the historical evidence about what the founding generation's experience with commercial speech was, he came to recognize that it was very difficult to exclude commercial speech from the protection of the freedom of speech. In his Washington Legal Foundation monograph, in which he argued that the proposed limits on tobacco advertising were patently unconstitutional, he cited both the Supreme Court's existing doctrine as well as the original understanding, and he cited a white paper written by several attorneys at Wiley, Ryan, and Fielding that summarized a lot of the historical evidence, and I think it's worth noting that one of the co-authors of that white paper was Daniel Troy, who clerked for Judge Bork and who would go on to write a fairly extensive and I think underappreciated law review article in the Yale Journal of Regulation, showing quite extensively that it is difficult to argue that the founders did not see commercial speech as part of the freedom of speech and the freedom of the press. Among other events noted, there's a fairly famous story involving attacks on Ben Franklin, who among other things was a pamphleteer and a commercial pamphleteer who was attacked for publishing an advertisement that referenced sea hens and black gowns, an advertisement that was very displeasing to local clergy. It's unclear whether they didn't like being referred to as black gowns or whether they didn't like being categorized as the equivalent of loose women in terms of the undesirability as passengers on ships. But either way, it's pretty clear that the founding generation saw the freedom of speech and freedom of press as integrally wound or up in the communication of information, and that information that was important to individuals as both citizens and consumers, and it's not even clear that the founding generation saw that as a meaningful distinction. I think also, as Judge Bork did note in other contexts, the line between political and non-political speech, as other scholars have noted, is a lot more difficult to draw than many have sometimes appreciated. As the Supreme Court noted in the Virginia State Board of Pharmacy case, for instance, the free flow of commercial information is, quote, indispensable to the proper allocation of resources in a free enterprise system. It is also indispensable to the formation of intelligent opinions as to how that system ought to be regulated or altered. Not all speech of political relevance is expressly political. Not all political discourse is directed at the state or concerns the state. Indeed, if we see the First Amendment as playing an essential role in democracy and self-government, as Judge Bork certainly claimed, then we must recognize, I think, that not all self-government concerns participation in the democratic process or our relationship with state entities. It often entails and involves our relationships with each other, the formation and the creation of civic institutions, Madisonian factions, Buchananite clubs, and so on, and that these collective institutions are as important to self-government as the claims we make about the political process, and that commercial speech, now as ever, is part of that discourse. People engage in acts of both self-definition and communication with others, not merely through writing letters to the editor or giving political speeches, but through the products they buy, the way they define themselves. The person who buys a Toyota Prius is often not merely making a judgment about what sort of car meets their needs as a consumer and a driver, but is often also engaged in a political statement about the relationship we should have with the planet, with the climate, our energy use, and so on. And anyone that pays attention to advertising, and certainly the advertising literature, it's clear that producers and advertisers are well aware of this. Those that advertise free trade coffee are not making any, or fair trade coffee, sorry. There was once a coffee vendor in Bozeman, Montana, that had a sign on its wall, or on his window that said free trade coffee, and a bunch of us who were at Bork at the time thought, aha, we found a artisanal coffee place that we can attend without guilt. And then we, after talking with the owner of the store, we realized they had made a mistake and quickly changed the sign. But the point is that when vendors and marketers make these claims, they are making they're not merely making appeals to consumers, they are also making implicit political claims, and I'm seeing just about out of time, so I'll just quote a new book by Martin Reddish that I think makes this point quite well. Speech concerning commercial products and services can facilitate private self-government in much the same way that political speech fosters collective self-government, and both forms of self-government foster the values of democracy. So I don't think it's an anomaly that Judge Bork came to embrace protection of commercial speech, and that even if in his writings he did not fully explicate the reasons why, I think that both his commitment to original public meaning of the Constitution and his later recognition that the boundaries of political speech are not as crisp and clear as some commentators might hope are certainly sound reasons why commercial speech is as worthy of protection as many other forms of speech, including expressly political speech. And since I hear Henry's timer, I will stop there.
Thank you very much, John. And now we have John Harrison.
Thank you, Henry. I never met Alchian. I did use his text in an intermediate microeconomics course I took as an undergraduate at the economics department of the University of Virginia, an economics department that, in a story that Fred McChesney tells very well, managed to run off two future winners of the Nobel Memorial Prize in Economics. One of them, of course, was James Buchanan, one of the subjects today. The other was Ronald Coates. So if you look at the first footnote of the problem of social cost, it says professor, University of Virginia. Coates was run off to Chicago, creating the Chicago connection to Robert Bork and, of course, Doug Ginsburg. Since I never met Alchian, I can't say anything about Alchian. I'm instead going to talk about Buchanan and Bork, constitutional theory, and in particular, public choice and judicial virtue. Both Bork and Buchanan, and since this is the Bork panel, I will mainly talk about Bork and talk about specifically judicial virtue as a form of public virtue, but there will be some Buchanan-type constitutional theory in here. Both Bork and Buchanan regarded themselves as working in the Madisonian vein. Bork, in Neutral Principles and Some First Amendment Problems in 1971, said the design of the Constitution is Madisonian. He meant something specific by that. And Buchanan and the public choice theorists, like James Madison, throughout the Federalists, and especially in Federalist number 10, were trying to deal with the question, how can you design a constitutional system if you believe that the actions of government officials, elected and unelected, will be governed not entirely by their views of public virtue, what is good for the community, the permanent interests of the community, as Madison said, but also by their narrower interests and the narrower interests of their constituents, which will be transmitted to them often through electoral mechanisms. That has to be taken into account. One thing that the American framers are often quoted as having said to have believed, and I think they did, was that there is such a thing as public virtue, but that it is necessary to economize on public virtue. It is not in limitless supply. By public virtue here, I mean a devotion to the good of the general public, again, as opposed to that of narrow interests, either of a particular government official or the narrow interests of the official's constituency. Since I'm talking about Bork, I'm going to talk about specifically judicial virtue, something that he was very much concerned with. The idea of judicial neutrality was central both to his thinking as a constitutional law scholar and to his work as a judge. And there's a problem with judicial virtue. And the problem is this. You might think that what is virtue in a legislator or an executive official is vice in a judge. Because for a legislator or an executive official, to have public virtue is to follow one's conception of the public good, as opposed to narrow goods. That's the right thing to do if you're a legislator. But if you're a judge, following your own view of the public good is, of course, judicial activism, is, of course, lawless judging, is legislating from the bench. So it is vice, whereas it is virtue in other people. Is it possible to resolve that paradox? I think it is, because the idea of public virtue means having some kind of ideological commitment, a commitment principle, rather than a material interest. And one of the great things about ideological commitments and commitments of principle is that people can have them to all sorts of things. They can have them to the dictatorship of the proletariat or to the electoral college. So the important thing for judges is to have the right ideological commitments. And if you start thinking about the judicial role in that way, I think it's possible to see how judges, if they have the right ideological commitments, can perform an important role in Buchanan-style constitutional theory. What can judges add to a constitution? Well, they can add commitments to the principles of the Constitution, and in particular, one principle of this Constitution, which is the rule of law. They can add, as Judge Posner has pointed out, being the sort of person who likes to solve difficult legal problems, and can perform, I think, this function. The function, as it were, of alerting the people to serious but hard to detect defections by the government. It's one of the serious problems of constitutional theory, insofar as it is designed to create a constitution that will serve the public interest and not just the interest of the governors, is once the people have gotten organized by a constitution, by a political system, and have coordinated their efforts by following their leaders, they have the problem of defection by the leaders. And it may be hard for the people to tell whether the leaders are defecting or not, and, if necessary, in extreme circumstances, to withdraw their support from the leaders. Well, one thing judges can do, if they have the right ideological commitments, including their commitment to the rule of law, is serve as a warning mechanism when that happens. And I don't mean, when I talk about this function, as sort of what we think of as run-of-the-mill constitutional adjudication, which works, as it were, within the political system. I mean a much more important, much more rarely seen function of judges, which is to say that something seriously wrong is going on. And I'm going to draw, to say what judges might contribute to that, I'm going to draw on a statement made by Judge Bork and Judge Ginsburg's colleague Harry Edwards, who said that even though the D.C. Circuit is thought of as a very politically divided court, in fact, about 85% of the cases that the D.C. Circuit sees are easy. And then comes the interesting part. And the next 10% are not easy, in the sense that you have to think and read the briefs and do some research and work through the problems. But then, to a well-trained lawyer, they are easy. And the other 5%, those are ideological, and people tend to be influenced by their ideologies. Well, my suggestion as to what judges can do for Buchanan-style constitutional theory is in the 10%. In situations where there is some threat to the people from their governors, but it's not obvious because the governors are trying to disguise it. And so people who love the Constitution but aren't well informed can't say, well, that's obviously wrong. That's like refusing to hold an election. Now, what the judges can do is, in the 10%, say, no, it may not be obvious that this is defection by the governors, but it is. Well, that's a role for judicial virtue, a specific kind of virtue that you might expect judges to have. Is it found in the actual American constitutional system and in American constitutional history? And that takes me to the next question. The first one was sort of ideal Buchanan-style, Madison-style theory. What contribution can judges and judicial virtue make? The second question is, well, how does the system work? And is there any particular kind of judicial virtue that it actually produces? And I think the answer is yes, but that the answer to that question then poses a problem. And one way to get access to my broader answer is to think at the very beginning and ask, in a quite specific sense, what was the function of federal judges as far as the framers of the Constitution were concerned? And one slightly grubby answer, but with considerable evidence behind it, is that the function of the federal courts was to make sure people paid their debts, whether they wanted to or not. What is the diversity jurisdiction for, after all? And the framers might well have believed that they had set up a system that would select as judges people who would have an ideological commitment to that idea, and hence would have a particular form of judicial virtue. That the sort of person who would become a federal judge, who would be indirectly selected at multiple levels by the indirectly elected president, confirmed by the indirectly elected Senate, and would then serve for life and be a lawyer, might well be the sort of person who would uphold property rights against, for example, debtor relief legislation. And certainly it worked for a while, but one of the things about the American constitutional system is that people come to understand it. And before too long, a lot of people thought that what was going on with the national government, and with the federal courts in particular, was very bad. That it had been captured by a narrow elite and enabled by judges who would do things like say that a national bank was constitutional, when a national bank was nothing but a piece of rent-seeking by the elites. Well, lots of people complain about the weather. Hardly anyone ever tries to do anything about it. Lots of people complain about the American constitutional system, and back in the 1820s, somebody decided to do something about it. It was Martin Van Buren, the sly fox of Kinderhook. And he thought that the national government had been captured by narrow interests and enabled by the courts, and he decided he was going to fix it. And in order to fix it, he thought it was necessary to create a political mechanism that was more powerful than the federal courts, the presidency, and the Congress put together. It was necessary to create a political party that would control all of those instrumentalities on behalf of the majority of the people and keep the dangerous rent-seeking minority out of power. The first party was, of course, the Democratic Party. And the great thing about Van Buren-style political parties, starting with the Democrats, is that they are parties of constitutional principle, not just parties of policy, but parties of ideas that are supposed to be followed and enforced by the courts and followed by the coalition that constitutes the party, even when, in some circumstances, they go against the interests of the coalition. The central constitutional principle of the Democrats was strict construction of federal power, even when it might benefit, in a narrow sense, some Democrats. That coalition, forming a party of constitutional principle, was succeeded by another one, starting around 1870, the Republican coalition. It had constitutional principles, an open interstate market protected by a dormant commerce principle, strong protection for private property rights, especially against regulation. That coalition of constitutional principle was replaced by another coalition of constitutional principle, the New Deal coalition, which stood for strong federal power and judicial protection of the various minorities that made up the New Deal. Whether there's been a governing coalition, a party of constitutional principle, since the collapse of the New Deal coalition is a difficult question. There have been attempts to create one. Now, if that's what's going on in American constitutional politics, majority coalitions, not universal coalitions, but majority coalitions, coalescing around constitutional principles, then judges with a particular form of judicial virtue, commitment to certain ideological principles, can play an important role in it. Because one of the problems, of course, just as the people face possible defection by the governors in the Constitution, in general constitutional design, So the different components of an electoral coalition always have to fear, I will support the other guy's position, and then I will be double-crossed because there is sequential performance. Is there some way to make a commitment, to have a commitment device, and in particular a commitment device to the constitutional principles that hold the coalition together, even when it is recognized that, of course, from time to time, the principles will bite even members of the coalition with respect to their narrow or short-term interests? The answer is, of course, that's something the courts can do. That is a role for the judges. They serve as a commitment device for a governing coalition, a coalition of constitutional principle. I'm going to bring Robert Bork in here to give him as an example of that very thing happening. Two constitutional principles of what you might think of as the Reagan coalition, one that sought to become hegemonic the ways the earlier parties had sought to do and did not succeed in doing so. But it had constitutional principles. One of them was Roe against Wade was wrongly decided. And that principle was adhered to by people within the coalition, including those who, at least like Robert Bork when I took constitutional law from him, did not object to Roe against Wade as a policy matter, but believed it to be wrong on the Constitution. That's an issue, abortion, on which there were serious defection incentives by elected officials. Lots of Republican elected officials either were pro-choice or were perfectly happy with Roe against Wade taking the issue off the table. But the coalition had coalesced on the principle that no, as a constitutional matter, Roe was wrong, and this is an issue that must be decided through ordinary and not through judicial politics. How to hold the coalition together? One answer is judges as a commitment device, like, for example, Robert Bork. Another issue with similar politics within the Reagan coalition are the constitutional bans on race discrimination strictly colorblind, or do they allow racial preferences? Again, an issue on which, as a matter of principle, the coalition was, I think, committed to the answer, they are colorblind, but as to which there are substantial defection incentives for particular politicians, something one saw quite a bit of in the Reagan administration. Once again, a judicial appointment is a means of commitment because the coalition can see when the judge is appointed, is this somebody who stands for the principles, and can expect, if it's a person of judicial virtue who has an ideological commitment to those principles, that they will then be enforced from the bench by somebody with life tenure, so you won't have the problem of the rest of the coalition backing out. Judges are an excellent commitment device, provided that you get the right people. Now, if you think about the two parts of what I said, the two forms of judicial virtue, one a general one, one a more specific and relative one defined by the constitutional commitments, what Keith Whittington would call the constitutional constructions of the particular coalition that is appointing judges, may be inconsistent with one another. And that raises the last question that I want to ask. If the way American constitutional politics actually works is for coalitions to come together on particular principles that are constitutional, but nevertheless are generally debatable, like those of the various coalitions that I've discussed, will that completely crowd out the other function of the judges? That is to say, are the two functions inconsistent with one another? The function of protecting the people against the government, enforcing the general principles of the Constitution, and the function of enforcing the particular commitments, the particular constructions of the coalition that appointed the judge. Well, like a law professor, I don't know the answer. But I will say a couple of things by way of how to decide what the answer is. And the first question is, well, if you think of political parties as being majority coalitions but not total unanimous coalitions, the question, will judges continue to perform the function of protecting the people from the governors, depends on whether there is also a politically effective, near universal coalition within the constraints of which any narrower but majority coalition managed by a political party operates, that wants to make sure that whatever else happens, whatever happens in those 5% of cases, that the judges continue to perform their function of warning the people if something is seriously going wrong. Is there ongoing political support for that? That's the first important question. The second important question, and that's about broad politics, the second important question for will judges perform both of these functions, but only the function relative to the constitutional commitments of the party coalition that appoints them, is back to judicial virtue and judicial virtue in individuals. And that's the question, is virtue, as it were, indivisible? is the sort of person who has the commitments to what the coalition believes in, because that person believes in constitutional principles and believes in the rule of law, also going to be the person who has the broader kind of virtue, a commitment to the entire constitutional system, including the parts that the coalition itself just takes for granted. Will someone who was selected for a narrower kind of judicial virtue probably have the other kind of judicial virtue? That, of course, is one of the great difficult questions. I don't know the answer, only the shadow knows what evil lurks in the hearts of men. But I do know that for Robert Bork, at least, virtue was indivisible.
All right, we have two commentators. Tom Lambert's going to lead off.
A challenge putting together a Bork panel, of course, is finding people who can comment on all the things that Bork was an expert in. And I think, well, we may have failed here. I'm incapable of talking about constitutional theory. Eric tells me that I would be better at talking about antitrust. And so I'm going to talk about Judge Ginsburg's paper, which I very much enjoyed, and I agree with almost everything in the paper. In particular, I agree that Robert Bork succeeded in focusing courts on the maximization of consumer welfare as the objective of the Sherman Act. I also agree that this was a very salutary development for the reasons that Judge Ginsburg emphasizes. Unfortunately, a commentator's job is not to wholeheartedly agree with the paper, so I have the obligatory quibble here, and hopefully time to ask a question in addition to making my quibble. As Judge Ginsburg points out, Bork's claim about antitrust and consumer welfare is really a twofold claim. First, that legislative history shows that the purpose of the Sherman Act was to maximize consumer welfare. But then he equated consumer welfare with total welfare, the wealth of the nation. He writes that the goal of antitrust is to minimize the sum of productive and allocated inefficiencies. Basically, total efficiency is what I mean by consumer welfare. And that's not what many economists mean by consumer welfare. There's whenever a seller sells a product to a buyer, wealth is created if it's a voluntary exchange. The wealth is measured by the difference between the marginal cost of producing the unit that's sold and the reservation price, the willingness to pay of the person who ultimately ends up with that unit. That's total surplus, but it's divided between producers and consumers. The producer gets the difference between the price that he puts in his pocket and the cost of producing the unit. The consumer gets the difference between his willingness to pay for that unit and the price that he has to pay. That's consumer surplus. So normally when we talk about consumer welfare, we're talking about the difference between price and reservation price, how much you subjectively value the thing that you've gotten. Bork conflated the two, and when he talked about consumer welfare, he was talking about total welfare. So Judge Ginsburg makes a claim in his paper, and he backpedaled a little bit in the talk from something that's in the paper. But he says, if I can find it here, that the Academy has been fairly critical of this claim that the goal of the Sherman Act is to maximize consumer welfare. And Judge Ginsburg writes, yet the Academy has failed to persuade the judiciary, and Bork's consumer welfare thesis has become one of his many enduring contributions to U.S. antitrust law. Now, when I read that, I thought, well, I'm not so sure about that. There are plenty of places in the federal reporters where the courts say, well, the purpose of the antitrust laws is to enhance consumer welfare, maximize consumer welfare, antitrust is a consumer welfare prescription, etc. But those claims are consistent with the view that Landy has taken, that the goal of the antitrust laws is not to maximize total welfare, but to prevent redistribution of welfare from consumers to producers. And so to decide whether Landy is right or Bork is right, what we would need to come up with is a practice that involves enhancement of total welfare, but perhaps a reduction in consumer welfare. And say, well, what have the courts said about that sort of a practice? If the courts say, well, that's good, then Bork would seem to be correct. If the courts would say, well, that's troubling, then Landy would seem to be correct. Well, we have such a practice, and the practice is tying. Tying, by the way, is really the only practice that I can think of off the top of my head where the courts have not followed Bork's recommendations in the antitrust paradox. Horizontal mergers, vertical mergers, resale price maintenance, exclusionary conduct like predatory pricing. The courts have very much moved in the direction that Bork suggested, but not with tying. We have a really weird rule on tying, this quasi-per se rule. Tying is per se illegal if the defendant has market power in the tying product market, two products are tied together, and the tie in affects a not insubstantial dollar volume of commerce. It's really sort of a stupid rule. Tying, though, can enhance total welfare and simultaneously reduce consumer surplus. Now, it can do it two different ways. So I know there are a lot of economists here who will, this is very basic, but there may be a few common law people out here who I need to explain this to. One way that tying can have this effect is through metering price discrimination. This is something that Aaron Director came up with, and it was then published by Ward Bowman, this argument. But here's the strategy. If you're a monopolist, you set your profit maximizing price. That is above your cost. And so there are lots of people that would like to buy your product and are willing to pay more than it costs to produce that product, but they're not going to get it if you charge your single profit maximizing price. At the same time, when you charge that profit maximizing price, there are lots of buyers that would be willing to pay way more than that profit maximizing price. So a monopolist might decide, I'm not going to charge my single profit maximizing price. What I'm going to do is lower the price of my monopoly product down to competitive levels, but I'm going to require anybody that buys my tying product also to buy a tied complement, and I'm going to charge a super competitive price for that. So the classic example, is a printer and ink. If you want to buy my printer, you also have to buy my ink. I'm going to charge you a competitive price for the printer, but I'm going to jack up the price on the ink. Now, the effect of doing this is to enhance total output. Low-use users of the product who have lower reservation prices, presumably value the product less, will now enter the market. They can afford to do so because the price for them is below the profit-maximizing price, single product price. At the same time, high-use consumers, high reservation price customers, those who value the product more, end up paying more. Their surplus is reduced. So in most circumstances, when you have a metering tie-in, you have an increase in output, overall efficiency, total efficiency increases, total surplus increases, but consumer surplus will fall. So that's one situation where you can have an increase in total efficiency, but a reduction in consumer surplus. Tying can also be used to usurp surplus when demand for a seller's different products is not positively correlated. So the idea here is that the seller sells different products that different consumers value very differently in a way that's not positively correlated. George Stigler came up with this idea in a wonderful article on the Lowe's case that involved distribution of films. So imagine that you have two movie theaters and two different films. One of the films is a fancy art film that would appeal to intellectuals, The British Patient, let's call it. Another is sort of a raunchy teenage comedy called Porky's. You also then have two movie theaters. You've got your indie cinema that shows art films, and you've got the megaplex that appeals to teenagers. These two buyers, or licensees, I guess, of the film, are going to value these two films differently. So the indie cinema values The British Patient at, say, $8,000, but Porky's at only $3,000. Megaplex values The British Patient at only $5,000, but would pay $7,000 for Porky's. Now, if the licensor here has to charge a single price for its two films, The British Patient and Porky's. If we assume that its marginal cost is zero, it's not going to be zero, but it's going to be low. If we assume that its marginal cost is zero, it would do best to price Porky's at $3,000 and The British Patient at $8,000. That way it licenses both films to both licensees. It'll make a total profit, if it does that, of $16,000, and there will be a consumer surplus of $7,000. Indy gets no surplus on the Porky's. Megaplex gets no surplus on The British Patient, but they do on the other films. Now, if the licensor is to tie these two films together, it can license the bundle, the package, for $11,000. Both Indy and Megaplex will be willing to pay $11,000. But consumer surplus here falls to $1,000. Licensor's profits go up to $22,000. All right, so in my example here, I don't show an output increase, but it's very easy to come up with examples where this would actually increase total market output at the same time reducing consumer surplus. All right, so what have the courts said about tying? The evidence here, I think, is mixed. In the Jefferson Parish case, 1984 case, where the court affirmed the per se rule against tying, the court said did three things that suggest that it believes these surplus extractive practices are anti-competitive, inconsistent with the Sherman Act, even if they do increase overall output. They quote the Fortner dissent, where they say tie-ins may be used as a counting device to affect price discrimination, that's metering, and they may be used to force a full line of products on the consumer so as to extract more easily from him a monopoly return on one unique product in the line. These were part of the reasons that the majority in Jefferson Parish wanted to sustain the per se rule against tying. They also observed tying can increase the social cost of market power by facilitating price discrimination, thereby increasing monopoly profits over what they would be absent to tie. So this to me suggests that the courts have bought into the notion of consumer surplus, but not total welfare being the goal of the antitrust laws. On the other hand, in 2006, the last tying case that the Supreme Court decided, Independent Inc., the court considered an alternative holding that had been suggested. The issue in that case was, does possession of a patent on a tying product create a presumption of market power? The court held that it did not, which was quite sensible. But an alternative holding that had been suggested was that presumption should exist when you have a variable proportion requirements tie-in, the sort of metering tie-in that I was discussing earlier. Ian Ayers, Barry Nailbuff, Lawrence Sullivan filed an amicus brief with the court where they said we should have this presumption in the case of metering because in a case like that, a tie-in can extract consumer surplus and would be anti-competitive. The Supreme Court rejected that view. And by the way, Justice Stevens wrote both Jefferson Parish and Independent Inc., so the same justice. The Supreme Court said in this case, we recognize that tying may result in price discrimination, but price discrimination occurs in fully competitive markets. Many tying arrangements, even those involving patents and requirement ties, are fully consistent with a free competitive market. This, I think, is consistent with the Bork view that the goal of the antitrust laws is to maximize total welfare, not just consumer surplus in some. As a normative matter, I agree that antitrust should strive to maximize total welfare. As a descriptive matter, I agree that courts have settled on the maximization of consumer welfare as the exclusive goal of antitrust, but I'm not sure that they've agreed to equate consumer welfare with total welfare. That seems to be an open question.
Thank you, Henry. I was invited to speak on the constitutional law topics, but I was also notified in advance that Professor Adler's paper would be forthcoming before the conference, and so I don't have any prepared remarks on it. I'm not well up to speed enough on commercial speech doctrine to comment on it. I would want to then focus on Professor Harrison's paper. And I find it an interesting and, as the academics say, generative essay about Judge Bork and the Supreme Court. I really like the angle that he's taken to explore the Supreme Court where it sits in American politics today. I probably use that angle, as will become clear, to take a different perspective. But a good short essay is good in that respect. It provokes people to take the point of view it embraces and run with it, and that's what I hope to do here. I hope some of the observation I have will help Professor Harrison clarify the paper and deepen it when he submits it to JLEP. Now, before starting, I want to warn, I'm not as close to Judge Bork as John Harrison is, or as any of the panelists in the last panel were to Alchian. I wasn't his student, I wasn't his clerk, I wasn't his academic protege, and Tom could say the same thing too. I, in my writings, focus on natural law and rights theory, and for those of you who know the in-house debates among judicial conservatives and libertarians, there's a saying that true believers aren't as hard on infidels as they are on heretics, and these kinds of debates among judicial conservatives and libertarians can have that spirit. And I hope not to say anything that's unduly critical, but I just want to flag that I'm at a more respectful distance than a lot of other panelists have been to the subject of their panel so far. Now, on to the paper.